letters testamentary.
Adjourn. Add the day, see French word, for when it was turned around.
The day it was.
Turned around. Adjournement. Adjourn.
So, and I like point form on that document.
So, in regards to that, and yeah, what titling it, notice of affidavit of letters testamentary.
Well, it's either one of those or it's an affidavit.
What you're achieving is testamentary capacity and the acknowledgement of the will of the testator.
Right.
We understand that we have in the visa failure to comply with the will maker's instructions. That is an interesting phrase in quotations.
So we have to find that.
Failure to comply with will maker's instructions. Why don't I move the word will out so you don't question my capacity? Failure to comply with testator's instructions.
Yeah, or wishes of the testator.
What if we gave a separate notice to the AG on that and gave him a copy of that? Do you think that the AG, who was the big boss of the judges, would say in the back room, "Oh, give it in his favor because he's got us by the kahunas on paper already. I gotta get a stamp to the court on my paperwork somehow."
Well, there's an
Okay,
issue here that.
this is like a one-page thing, can go with it, can go with this, whatever we, on legal sides, with this one-page
That's the
thing.
legal side.
And it says, it's got your jurisdiction on it, they got your state of Vermont, district of, and then probate court, RE, the estate of, and then they've got letters testament, and it says to, of, and then whereas on, and then an instrument purporting to be the last will and testament of the above named decedent was proved and allowed by the court as the last will and testament of the deceased. A certified copy of the order of will attached, and whereas you were in the name of the will executor thereof, and having filed the bond satisfactory to the court. Therefore, the court commits the administration of the estate to you. You shall administer the estate according to the will and laws of the state. So you're sending this to them, very simple document. We might have to reword some of that. I don't like a lot of that.
Well, I'm appreciating allowing the will, it's in brackets.
Yeah.
You'll notice we talked about the margin.
Well, I kind of see this
They'll
as
accept
as
this.
telling the guy with the
Specific
gun in your face to
code.
say, you can put.
It's gonna go under the paperwork, it's gonna go margin. That code's gonna qualify in the margin. They're still gonna operate, but you're gonna get a redacted file.
Mhm.
Yeah, I want to make a distinction here. The birth registration does not record your birth. It
No.
records the birth of a
Of the
legal
event
person.
You weren't birthed
given
anyway, you were
name.
born.
It's the birth of the event given name.
Right.
That's
But
all.
that's what it is, that's the legal person itself.
Yeah.
That's the registration that creates the legal person.
The word
That legal
whereas in
person-
there does it.
That legal person is not a decedent in the public till the death certificate is issued.
Correct.
It's alive in civil, it's civilly alive.
Can I interject? There is a death certificate issued already. That's how the plot number gets purchased. It's all on hold. It's all in hush-hush secret trusts. And
That's for the man. The plot is for the man, not the legal person.
No, for the legal person, who's on the tombstone, the legal guy.
Who's underwriting who's underwriting the other?
It's all up
in
to
BC,
non-deserved.
it's in BC assessments. Because it's in an English floating charge position. Its true value will not happen until 6 months after the death of this body.
Right,
Well,
when a
that
death
is-
certificate for the legal person is issued.
Yeah.
Right now, they're deeming the man, not the name.
No, correct.
So when you're talking about these letters testamentary,
Excuse me, I'm having a hard
Well, I
time
was
hearing
just-
you.
yeah,
When we're finished with this, I have a question.
letters testamentary should be an oath of office as executor, because there's no decedent as yet.
That's
That's right, so, okay, so there's this letters testament, there's this affidavit, or this whatever the document,
Well,
this-
whatever we decide to call it, and an oath of office by the executive. all
Death
one
certificate
thing.
exists.
Well, I don't know if you need to.
What?
But it's not
What-
insurance.
What I was gonna say here
You have to
was,
give
This
the
would be
public
nice, it's appearance.
executives.
hang on, one voice at a time.
when you talk about the margin note in this, so would you think it might be prudent then to make one of these up exactly the same with a border, and do them both?
You know, I like that idea.
Yeah,
I does.
yeah.
Winston said something which I found very appealing. Make up your own forms.
Yeah.
Well, that's the whole thing here, but.
You're making a
saying-
trade brand mark that can't be duplicated without implications for plagiarism.
I think
Plagiarism,
His
excuse me.
quote is, why are you living in someone else's
Law
law
firm.
firm?
Yeah.
The thing here is law forms is the key to letters rogatory are letters from one court to another. Different jurisdictional courts.
Which is why.
And the fact is that the.
Valid
an
points,
estate
valid points. He's not dead.
And an estate is not statutory defined. An estate exists in common law, in equity, in admiralty, in every other jurisdiction. It simply is the sum total of your property and obligations.
T4 sum.
Okay.
T4 sum.
Yeah, but the thing is, the executor is the final authority over that estate.
Agreed.
Because estate law is governed by trust law and directed by probate law. Neither of them have jurisdiction.
No.
Okay, an estate is an estate. The executor is the highest authority.
This will
Therefore, he
constitute
is-
the jurisdiction.
Yes.
And he is the judge who's
He will
issuing the
adjudicate on
letters
the issue.
rogatory to the other courts.
Yes.
Which happens to be-
That's it.
Which is
That means
A-
accept the settlement agreement all the way around.
A, Minister of Foreign
You're gonna get
Affairs has what's coming in internationally.
Yep.
The Governor General for the Queen under her oath, which is common law.
In this
And
nation,
the
within
attorney-
and without.
And Attorney General, because under Admiralty, he's dealing with equity law.
Yeah.
Okay? So letters rogatory are going to those courts.
Yes.
The Queen is at court, don't forget, that's what
Yeah.
they call it.
Right.
Buckingham
Court of equity
Palace,
is
she's at
24/7.
court.
Well, wherever she goes,
Wherever the court is.
follows the
wherever
sovereign
court
is.
Truth is never
That's
to
your
be
court.
out of season.
Yeah.
So the court
That's why
exists
the
within
king
the
is always
purpose.
at court, they always called
The
it that
court
for
issue,
hundreds of years.
whatever you're doing, you can do
And
it.
the Attorney General is operating the courts in Canada, and you have to notify the Minister of Foreign Affairs that you're bringing it into this jurisdiction, and the executor is the highest authority, so it should be letters rogatory to put them on notice that you're the judge of that estate.
Right.
And you'll be
I
the
like
judge
that.
of the claims
Yeah,
on
I
that
agree.
estate.
That's really
I agree.
That's
Can
what
we
you
read
are.
it?
Part, but what I have confusion on is again, where you got whereas I or whereas whatever, that's coming in the fiction there. Now, do we want to be the fiction?
Well, just
Or do you
hold-
want to come in
let's-
as the underwriter,
let's just
overwriter,
settle
or do you
this.
want to come in as duly?
Let's just settle this on the letters rogatory here.
He's offering
The
to-
definition in Black's Fort says, a request by one court of another court, one court of another court, in an independent jurisdiction.
Right.
Delaware.
There we are.
And the request
Okay.
is that they follow their protocols, honor their oaths,
That-
and their
well,
conscience.
But let's do the definition, that a witness be examined upon interrogatories. Question.
Interrogatory appeal.
Interrogatories, sent with the request. Okay, then they cite some case law here. The medium whereby one country, speaking through one of its courts, requests another country, acting through its own courts and by methods of court procedure peculiar thereto, and entirely within the latter's control, to assist the administration of justice in the former country.
Does that say?
Right.
A formal communication in writing sent by a court in which an action is pending to a court or judge in a foreign country, requesting that the testimony of a witness resident within the jurisdiction of the latter court may be there formally taken into its direction and transmitted to the first court for use in the pending action. So
Well,
I
see,
think
it's
it's letters
simple.
rogatory.
It has to be letters rogatory because you're asking the AG, the Governor General, and the Minister of Foreign Affairs
All these different courts.
to examine witnesses who happen to be...
Ministries to administer on the account in agreement.
Well,
No borders.
The parties that they are going to, the interrogatories are going to be those public officials who have or haven't sworn an oath of office. Because
Purporting
they
to
either
have. Purporting to have.
Well, purporting to have sworn an oath of office or operating under the auspices of someone who has. Okay?
UN member,
Pardon me?
a UN member, which is a signatory, which will be Canada
Well,
as
I
the
mean,
head
you
of
know,
the state.
if you wanted to go after the judge, you want them to go after the Crown or the other lawyer and the clerk of the court, they have an oath of office.
Anybody heard of the
But if
Crown
you're-
Liability Act?
Yeah, but if you're going after CRA, CRA used to be a
It's already
department of
done.
government, it no longer is. It is an agency and they are not officers, they are agents.
Private agent.
That's right, and therefore they're operating under an oath of office. The commissioner of CRA used to be the deputy minister of national revenue, but we sort of put the kibosh on that, I'm afraid. The new commissioner did not swear an oath of office, and there's a separate deputy minister now.
Which is important that we do continue separations so that we create the unification, they're under our authority to communicate our point, not go in the back room, gang up, and go against.
Well, they still have to be operating under somebody's oath. Somebody's oath is there as the liability. There's a bond. Their oath of office is their bond.
My word is my bond.
That's right, they swore their name.
Anybody heard of a prothonotary judge?
A what? Oath of notary?
With the notary, yeah.
That's two or more judges that accumulate experience of 3/4 of a century plus. Because they may have encountered issues like this before.
The title given to an officer who officiates as principal clerk of some courts.
Which makes you the prothonotary for the letters rogatory you're issuing.
Bingo.
Okay, because you've been operating in the capacity in which you've been vacant since you were born. So it doesn't make you a prothonotary judge, it just makes you a prothonotary, I believe. Isn't it?
Until you
Depends, you got the
until you
executive letter in there,
fill
now
the
you're
office,
executing and you're
rather than the
adjudicating
judge.
by warrant of adjournment.
Yeah, and see, the thing is, you hold all the authority, and you're coming to another court to say, there's matters pertaining to my court that you guys are adjudicating, and I want you to do interrogatories on any parties in there, any agents or officers that are in this matter, because I'm putting you on notice of the following. A, I'm settling the matter, and B, I want you to produce oaths of office. I want you to produce your authority to administer the estate without the authority of the executor, and...
Why,
when
if you're
done-
settling it, why are you going that
I
far?
wouldn't even go into
Settle
all that
it.
stuff. You've
Yeah,
already
you
gone past
settled
the
it,
point.
you're now creating a war by saying you don't have any right.
No, you're telling them you've settled it, and if they intend to proceed...
There's the big word, if.
Irrespective.
Okay, I needed that word. I had
Okay,
to bridge
if
with
they intend to proceed irrespective of the settlement that has been proffered in the matter, show cause.
Yes, reasonable.
And show
Stop there.
cause, yeah, show cause by
Stop there.
Yeah, don't overdo it.
rogatory, interrogatories. There you go.
Very valid points, man. Very valid. We're doing the best at honing this down. It would be nice to incorporate in there that understanding, and we've put it in the standing area for letters rogatory. We do it through seeking leave, if necessary, when they do not
Well,
acknowledge.
the thing is you're gonna send it to the court, right?
Yeah,
You know, like first thing
it's going to
you're
appear for me. I'll stay in the gallery and let them go.
You see, the thing is, you can send this, even if you don't have an issue, you can send it to the Attorney General and tell him that in the event that there are any issues to be settled, the claim is to be presented to the executor, who will settle them immediately.
Yep.
And in the event that there's any further ongoing actions without the authority of the executor granting the right to administrate the estate, or without production of an oath of office to show that the party coming forward has some authority and is bound by oath, then
You're
in
covering
that
a lot of great
instance-
points.
Then in that
Only
instance,
if
then
needed.
you want the AG to settle the matter by doing interrogatories, and then you send the Governor General a letter that you've sent the AG this letter, a copy is enclosed, and in the event that this matter isn't settled, you're serving notice upon him and informing him that you have forwarded this matter to the Minister of Foreign Affairs to ensure that they understand that you're coming forward as an internationally protected person, or you're coming from an international jurisdiction.
You
You're
need
coming
that
into
recognition
Canada.
in this whole ball game. Question, if I may. Does rogatory, or is rogatory mentioned in his EOL in any fashion?
No, look, hang on, just one to this point. The second part there, letters rogatory, what he's reading out, that is what you would be sending to the Governor General, because the second explanation there just fits this to a T.
Yeah,
That's my
Letters
second part of the question.
rogatory are oath of office, executor, EOL, they are the letters rogatory that you're sending. That's what they are.
And so my next two-part of this question is, in that EOL process, does it mention sending anything
No.
to the MOFA?
The process that is sitting there is extremely flawed.
Yeah.
But the fact is, it is still functioning to a certain degree, even though they're looking at it and deciding, how are we going to use a logical cleft stick to pry this apart so that it does not work anymore, so that we can supersede and ignore it, which I thought, to me, was the important piece of getting a room full of people together to pick this apart and understand why.
Le moffat. I like le moffat better, little skunk. But le moffat. We did cover that, eh? And I think that is a highly valuable point, being you're a foreign jurisdiction.
Yeah.
The Ministry of Foreign Affairs needs to corroborate your position. Corroborate your position.
See,
no, it's not
because you need to
supposed to
tell them
go
of consequences, okay?
Exactly.
Because
But you gotta
if
knock
this
at the
is-
gate first.
Yeah, and they have to know, they have to be noticed.
And you're bringing in your paper,
Yes.
and that
From
works.
from a foreign jurisdiction court.
Yeah,
Interpretations, accents.
exactly. Foreign nation, that's what you're
Interpretations, not
on.
criminal code.
Yes, it's on the
Just
criminal code
look at the
interpretation
state,
section.
there's the
Beginning of the
Secretary
book.
of State.
Section
Yes.
two.
Because that's the one that handles the international.
See, and letters
Section
rogatory.
7.
Just from one court to another.
Okay, letters rogatory brings forth interrogatories, right?
Yes, it
A
does.
set or series of written questions drawn up for the purpose of
Certificate
being
is evidence? Is that what you're talking about?
propounded to a party in equity, a garnishee, or a witness whose testimony is taken on deposition. So you're doing a deposition. A series of formal written questions used in the judicial examination of a party or a witness. In the taking of evidence on depositions, the interrogatories are usually prepared and settled by counsel and reduced to writing in advance of the examination. Written questions propounded by one party and served on adversary, who must serve written answers thereto under oath.
Okay, and this is very important to that point, right there. You were talking about like perhaps an affidavit of negative averment.
Yeah.
And while that is not exactly in the form of letters rogatory, some of the questions laid out in your letters rogatory, is there any evidence in existence or any belief on your part that those 6 treaties that you mentioned are no longer in full force and effect? Is there anything that says that the Vienna Convention is no longer in full force and effect, or the Hague Convention, or the Universal Postal Union Treaty? And then you carry on, these are the questions you're asking them, these are the precedents that you're saying.
Mac, would you like to take on that part of this project to fine tune that?
Well, that's what we have to,
LR,
we have to.
LR has to cover a lot of points, is what you're saying to me. Letters rogatory.
Well, that, we have, okay,
We
it's not something I
develop
can just
No,
do, we have to
R&D this.
argue over what goes in there and what
R&D,
doesn't.
Yeah.
Okay,
That's
so,
right.
see, and everybody,
Intelligently discuss.
Yeah.
Yeah.
yes. What we have to do is we have to distill it. It has
Distill.
to be relevant and it has to be intelligent so that they cannot be saying, these guys don't know what they're talking about.
Smoke break.
Smoke break.
I can make things rot.
I'm Sean Buckcroft.
I should try and get Gene to email, I forgot that what I was working on.
What can I ask again?
I should try and get you to email someplace here.
That's once.
Or just
Like
email
Gene,
it
you know, I mean, he may be dealing with American stuff,
Fuck, you
but I'll tell you what,
started
we need a parallel to what he's
Sure,
done.
look at it.
He's done an affidavit. He
Started
read
away.
it.
That's what we've been getting the whole weekend here, is the parallels right there. And he's been saying, we want copies of this, I want a copy of Michael's criminal code all marked up, that's what I want a copy of.
Just open it, look for the hearts. That's the best part.
Well, you know what, Michael's gonna be here for the week, so take his criminal code and I will
Yeah.
copy it, highlight it into mine, and then you'll have one you can work from.